In the matter of the people of the state of Michigan versus Gilbert Rodriguez, 24-3799.
Good morning, Your Honor. Matt Nagel for the people.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Rodriguez, who is present and now standing to my right.
Okay, today was the date scheduled for a preliminary examination for carrying concealed weapon. My understanding is that there's an unconditional waiver to the circuit court. Is that accurate?
That is accurate, Your Honor. There is no offer to put on the record at this time, but negotiations will continue. Sir.
That is correct.
Okay, and you are Mr. Gilbert Fernandez Rodriguez? Okay, sir, do you understand that you have the right to have a preliminary examination in this matter? You understand you're being charged with a felony, carrying concealed weapon. You understand the purpose of the preliminary examination is to require the prosecutor put forth evidence that would establish sufficient probable cause that a felony was committed, and then sufficient probable cause to charge you as the person who committed the felony. You understand that? Anybody promise you anything if you waive your exam? Is there any threats to get you to waive your exam? You're waiving it freely and voluntarily. You understand that this is an unconditional waiver, and then once this matter is bound over to the circuit court, if you don't get a plea offer, if you don't like your plea offer, you can't come back and decide that you want to have your exam. You understand that? Your waiver to be freely and voluntarily given. Your binder dates February 26th. So that's the date the circuit court's going to get the file from the district court, not a date that you need to appear in the circuit court, okay? Your next court date in circuit court will be a pretrial. Your attorney will be made aware of that date. Do you have any questions at this time? Bond was set at 2,000 personal recognizance. That will continue. Any additional matters for the record?
No, Your Honor.
You're all set.
Thank you, Your Honor. Thank you. Yeah, I'll send some more stuff.
Your Honor, it sounds like Holmes is going to be, it sounds like we're going to be running the exam on Holmes. However, my witness is, I haven't seen my witness yet. I don't know if it's due to the weather or if they weren't planning on coming. Maybe if we can bring
Holmes at
some
9, I can call that later.
Thank you, Your Honor.
And you said McCall wants and Chambers discussion.
Yes, please, Your Honor.
Yeah, all the time. Twice on Sunday.
Oh, you gotta go.
Leave the earpiece. They should be working. Okay.
It's gonna be reflected.
Mine or BIS? Let's see. Somebody gotta make noise. Can you hear it? I don't, but there's a mic right here.
Oh, yeah.
Stand. You have it on one?
No, I don't think so.
And test it out? No. Oh, there you go. Is it?
I hear something.
Okay, you might have to be like right here, because it has to bounce off of that.
Shepherd is here. I'm gonna meet with him down there.
And then I can tap on judges, Mike, and see.
Too far away.
Can you hear that, Mr. Freeman? Me tapping on this mic? No? Let's try the other one.
All rise.
Be seated. Okay, we just need a date, 30 days out to continue this. And do March 27th at 9. Does March 27th at 9 work?
That March 27th?
Correct.
Yes, Judge, that'll be fine.
We'll do that.
Because it's based on what you know, talked about, that was not my total.
Yeah,
So, talk to them and
Yes.
really happen, and then I'll let you know.
Okay, we'll get you notice to appear.
Thank you, Judge.
Thank you very much. Yeah.
At 9. Yeah. And you have not yet seen your witnesses for Holmes.
Not yet. Can I check the holder one more time? Jan?
Yeah, I think Holmes is in custody, correct?
I believe he is.
Yeah. Okay, I'm actually going to, I'm gonna have to clear these MDOC ones before I go downstairs and get anybody anyway, so,
Yes, Your Honor.
let's see. Let's see. Thurman, you said, who's handling Thurman? Okay. On the record in the matter of the state of Michigan versus Leroy Thurman, 25-00243, council appearance.
Thank you, Your Honor. Randall Berman on behalf of the people.
I'm Jeff Kaplan, P74943, on behalf of the defendant, who's standing to my right.
Okay, today was the date scheduled for a preliminary examination. This is for controlled substance manufacturing delivery. 2 counts, 1 under schedule 1, 2, and 3, 1 under schedule 4. There's a habitual offender third offense notice. My understanding is that the parties are going to waive the examination. Is that accurate?
That's accurate, Your Honor. We're waiving pursuant to a plea offer. Mr. Berman, you want to put that on the record?
Thank you, Your Honor. The offer that extended for purposes of today was to plead guilty to count 2 and dismiss the balance of the file, but negotiations will continue in circuit court. Thank you.
Well, that's the penalty. The dismissal includes the habituals, Your Honor. That's what my client was asking.
Correct. Okay. Do you have any questions for the court about that? Okay. And so you understand, sir, that you have the right to have a preliminary examination in this matter as to both counts? You understand the purpose is to require the prosecution establish sufficient probable cause that a felony or that these felonies were committed and sufficient probable cause to charge you as the person who committed the felony. You want to unconditionally waive your examinations? Anyone threatening you to do that? Has there been any promises extended to you to get you to waive your exam? Well, the plea deal is one thing, but this is an unconditional waiver, so.
Anything other than the plea deals?
Okay. You're waiving it freely and voluntarily, correct? Your bind over date's gonna be February 26th, and that's the date that the circuit court will get the file from the district court. You do not have to appear in circuit court on that date. You will not be arraigned in our circuit court unless your attorney makes a motion for you to be rearranged. Okay? Problem bond was set at looks like 7,000 cash surety that will continue. Any additional matters for the record?
Not on behalf of the people, Your Honor. Thank you.
Thank you. You're all set.
Whatever the cost.
Okay. So I can bring you the.
She's looking at 93 days on that.
Mr. Nagle, I don't know if you recognize that we can all hear you.
I apologize.
If you want to have a private conversation, you got to do that in private.
I apologize, Your Honor. I don't want to take it up anymore. The folks tonight.
I don't know if is that the victim on one of your matters?
For Forrest, yes.
If you need to go out into a private meeting room, you can continue the discussion, but I just want you to know that we can all hear you.
Thank you. Can we do Holmes really quick, Your Honor?
On the record, in the matter of the people of the state of Michigan versus Vincent Holmes, 24-03451.
Good morning, Your Honor. Matt Nagel for the people.
It's like-
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Mr. Holmes.
Are you waiving his appearance for this purpose?
Yes,
Okay,
So my witness is not available today, Your Honor. I don't see them in the hallway. A subpoena was served for my witness. But because I've had no contact, I don't know if it's because of the weather. I would request a adjournment. But I understand the defense probably has their position. I'll defer to the court's decision.
may it please the court, Your Honor. I counted no less than 12 people in this courtroom when the court first ascended to the bench. I made it here. Mr. Nagel made it here. The court made it here. Everybody else is here. Coupled with lack of information as to whether his witness called his office this morning. You know, I'm having trouble getting out of the driveway, or I slipped off the road. Or did the court staff receive a telephone call this morning saying, look, I'm on my way, but I'll just be late? Absent any evidence to that, I would respectfully move for a dismissal without prejudice. Thank you.
I'm assuming you have contact information for your witness.
We have contact information, Your Honor. I have not spoken to them just today.
If you would like to step out and see if they'll answer their phone, that's a way to flush out if they are having car trouble or trouble getting here. I'll give you time to do that. The other question is this a matter that you believe your office is going to reissue?
That would depend on our contact with the witnesses, Your Honor. So I can't answer that question at this time.
Okay, have you had contact with the witness before?
With the witness that's scheduled to come today, yeah, this is a witness, not the victim, but the witness saw what the defendant did to the victim. With the victim herself, we have not had contact yet. The information we have doesn't appear to be her most current contact information. But with respect to the witness, I will do as the court suggested and step out in the hallway and see if I can reach the name myself.
Okay, I'll give you a brief moment to do that. Thank you. Good morning, Ms. McComber.
Good morning, Your Honor.
Which matter are you handling?
Jeremy Shepherd. Mr. Carter. Mr. Carter, I can go see if I can find him.
Okay, are we running that one?
Yeah,
We're not?
no, it's gonna be a waiver. I believe.
Okay, if we can find Mr. Carter, that'd be one. Okay, on the record, in the matter of the people of the state of Michigan versus Ashley Renee Forrest, 24-03313, council appearance.
Good morning, Your Honor, Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Forrest, who is present and seated to my right.
And today that was scheduled for a preliminary examination for receiving and concealing a motor vehicle. How are we proceeding on this?
Thank you, Your Honor. At this time, there's been an offer extended by the prosecutor's office. We're working on finishing up the paperwork on that, but it is going to be a no contest plea. I do have a copy of the police report for the court.
Is there an advice of right?
There has not been, Your Honor. I apologize for that. I will take care of that immediately. Let's start reading that. I think there's a second page. No, don't worry about it.
Oh, for the, yes.
Yeah.
Yeah, well, because we might be on the same page, because I think. Because she didn't speak. And that's because of the knowledge.
And then the question, which just brought my attention.
And
There's restitution.
Yeah.
All right, all right. I think they're gonna know what that is yet, or.
Not yet, we'll know.
Okay. All right, all right. Let's go to the more full picture. You have any questions? Line later. It is. Take part. Run if I may approach.
Yes.
Oh, yeah, I got it right here. Thank you. Case sheet. Vice rights and neglected quick case number. I apologize. And then the Rusty, I believe that's in there stipulated in this report. For the contract.
Okay, Ms. Forrest, you can stand up. Okay, Ms. Forrest, you understand, there's been an offer extended to you for you to plead no contest to amended count 1, receiving, concealing less than 200, which is a 93-day misdemeanor. So is there restitution on this?
There is restitution, Your Honor. I spoke to the victims. I have paperwork that would be coming, and we'll have the restitution issue figured out by the time of sentencing.
You understand that there is an expectation that you'll pay restitution on this. This was the purpose of the no contest.
The purpose of the no contest plea is a civil liability down the road, because we don't have yet any information regarding damage to the vehicle, and
Well, you're talking about restitution?
not necessarily restitution, but anything else that may go beyond restitution. We're not
Well, what
sure.
is the restitution supposed to be for?
I believe it is for the damage to the vehicle, but I don't know if there'd be anything that would go beyond the would be recognized under statute. There was potentially also some lack of memory due to drug use.
Lack of memory due to some level of intoxication.
Potentially, yes.
Okay. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay. Is it true that you don't have a good memory of this incident? I'm asking you a question. I just swore you in under oath. You don't need her advice as to whether or not you have a memory or not.
Yeah, no, like,
Yes or no? Do you have a good memory or not? Do you remember the incident or no?
initial incident getting pulled over, yes.
Okay, you don't remember the incident
I
that
don't remember
gives
this.
rise to the facts of the case, correct?
Correct.
Okay, I find the reason for no contest plea appropriate. So do you understand that you, in order to enter this plea, would have to give up the rights that's listed in this paperwork here?
Yes, we do.
That means that you're gonna have to give up your right to have a trial, and you have the right to jury trial. You understand that?
Yes, we do.
You have the right to have the prosecutor bring evidence at your trial that would prove each element of the charge being brought against you beyond a reasonable doubt. You're gonna give that right up? That means you're gonna give up your right to be silent and not have silence be used against you. You're gonna give up your right to see, hear, or question in court any of the witnesses that are called to testify against you. You're gonna give up your right to waive the silence and testify at your own trial if you'd like, and the right to have witnesses subpoenaed to testify for you at trial. You understand that? Anyone threatening you to get you to give up these rights? Any promises extended to you to get you to waive these rights? Is that a no?
Yes, no, yes, it's not.
Okay, are you currently on probation or parole?
No.
You understand that by pleading guilty, it could result in a conviction that you may need to report to a current employer, or you may need to put this conviction on a future job application.
Yes.
It also could, by pleading no contest, it is, by pleading no contest, it could also result in a conviction that could have impact on where you can travel, or it could have impact on immigration status.
Yes.
You understand that? As to the amended charge of receiving and concealing property less than 200, you plead guilty, not guilty, or no contest. I have an incident with Fort Lansing Police Department. It's case number 245191061. Date of incident allegedly occurring on November 1st, 2024 at approximately 10:35. It says that the incident took place at or near South Martin Luther King Boulevard at Warwick Ave in the city of Lansing, Ingham County, state of Michigan. Officers, looks like Officer Carlson made a traffic stop on a gold Buick LeSabre exit on the parking lot 921 West Holmes and proceed westbound onto Warwick Ave from Martin Luther King Boulevard. The vehicle did not have a license plate attached to it. Officer attempted to catch up with the vehicle to initiate a stop for the motor vehicle under the motor vehicle code. Officer, however, got caught in traffic and continued to check the area and observe the vehicle going west on Hillcrest from Marion Avenue. The vehicle then went north on Christensen at a high rate of speed. The vehicle then turned west on Pleasant View. By the time Officer Carlson was able to catch up to the vehicle, initiated his overhead lights on the fully marked Lansing Police Department patrol vehicle. The vehicle had pulled into the driveway at 2040 Pleasant View. It should be noted that the person identified as Ashley Forrest had keys for this vehicle, and they were in the ignition at the time of the stop. The driver, later identified again as Ashley Renee Forrest, exited the vehicle and was detained without incident. She was handcuffed. Ashley stated that she was looking for a male friend at this address, and that she was waiting for a title on the vehicle. After being placed into handcuffs at the address of 2040 Pleasant View, the resident of that address exited the residence and asked if we were going to leave the vehicle there. Officers asked if the resident knew who Ashley was, to which the resident denied. Officer Carlson ran the VIN number of the vehicle in the law enforcement information network, and the vehicle came back stolen out of Lansing. Officer, let's see. Ashley Forrest was interviewed, and officers asked Forrest about the gold Buick sedan that she was driving. Forrest stated approximately 5 to 7 days ago, she purchased the vehicle from a black male named Devon. Forrest stated that she was with a friend standing at the Myers checkout line. Forrest stated she was talking to a friend about needing a car, but not having one. Forrest stated Devon told her he had a vehicle to sell her. Forrest said she thought he was kidding, but that he had a gold Buick in the Myers parking lot. Forrest stated she paid Devon $350 in cash for this vehicle. Forrest reported she desperately needed the car because she is homeless. Forrest stated she had the bill of sale and the cell phone of Devon. Forrest stated she does not want to provide her friend's information to me, and that her boyfriend currently has the bill of sale but refused to provide this information to me as well. Forrest stated Devon provided her with physical key to the vehicle. Any additional factual basis?
Not for people, thank you. Supervisor Einstein.
Not the fun thing. Your Honor, may I ask one question on my client? I know that this is a contest.
Yes.
Thank you. Ms. Forrest, given the facts that have been read into the record here today, do you understand that you knew or should have known that there was something going on with this vehicle, with this car, that this was too good to be true?
Ish,
I'm sorry?
like, it was not, it's not a nice car, because that makes sense, it's a beat up car. And so I literally thought it was like a dispute between boyfriend and girlfriend. So what I thought, I even questioned that. Like,
Oh, so you do remember the incident?
I remember parts of things. Like I remember, like I don't remember how I got, like how we initially got to my area.
You have a bill of sale?
Well, my boyfriend's in jail now. Like, he
That's
has,
how I asked you.
I did have those, yes. Do I have one in my first possession right now? No. Do I have those? Yes.
May I try again? May I ask one last question?
Factual basis is not going well towards receiving and concealing stolen property.
May I ask a couple of questions, Your Honor?
Yeah.
When you were negotiating the purchase of this vehicle, do you recall any presentation of a title to the vehicle?
We sat right there and he supposedly did a secretary say I gave him my address to send the title to.
Did you see the title? Did you ask to see the title?
I did, he said it was a lost title. that
And he was
I-
not, and he was not able to show you the title.
No, but he was willing, he showed me that he was on Secretary of State website.
But he wasn't showing you a title on the Secretary of State website.
I think she's already said no, but
So I think a reasonable person would want to see the title before agreeing to the final purchase.
I
So
don't
I
think
think,
that's that's sometimes you can buy a car from someone and they'll send you the title. If they gave her a bill of sale, she's making I don't know if she knows this person, but
well, there's,
if what this report says is true, is that she's standing in line, having a conversation about, I need a car, and someone right there who knows they need to sell a car says, I have a car I can sell you. I can sell it to you right now, and she's homeless. If all this is true, then well, you're not gonna let me finish my statement.
Sorry,
The plea fails.
I apologize. Yeah, I think,
I'm not accepting the plea. I don't have factual basis to accept it. And at this point, I don't even know that I have sufficient reason to take a no contest plea. So I'll let you further talk in private with your client about how you want to proceed. We can have an exam if that's what we need to do. Is there a conference room open over there? I'm gonna call Mr. Carter's case. Record in the matter of the people of the state of Michigan versus Jeremy Shepherd. File number 24-03662, council appearance.
Good morning, Your Honor. Natalie Maycomb, on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Jeremy Shepherd, who is present.
Okay, Mr. Shepherd, today was the date that was scheduled for a preliminary examination. This is for bond absconding, tampering with an electronic monitoring device and 2 counts of weapons, felony firearm. And my understanding is that we're not having an exam, is that correct?
That's correct, Your Honor. My understanding is that the people and the defense will be unconditionally waiving the right to hold a preliminary examination. This matter would ask the case be bound over on the charges in the complaint.
Is that accurate, counsel?
It is, Your Honor. I've had the opportunity to discuss this matter with my client. I've also had the opportunity to discuss with him what a preliminary exam is. It's his desire to unconditionally waive this preliminary exam and move to circuit court where this case will be disposed of one way or the other.
Isn't that the prosecutor? Or she might have run that. Because she's wearing her. Okay. They must be done over there.
May I approach?
Yes, thank you.
Oh, do you need this?
Okay, Mr. Shepherd, do you understand the purpose of the preliminary examination?
I do, Your Honor.
You want to give that examination right up today?
Sure.
Anyone threatening you to do that?
No, ma'am.
Is there any promises extended to you if you give up your exam?
No, ma'am.
And you have signed the waiver stating that you're giving up this exam freely and voluntarily, correct?
Correct, Your Honor.
Okay, your bind over date is February 26th. That's the date the circuit court's gonna get the file from the district court, not a date that you need to appear in circuit court, okay? You'll appear at the next court date, which would be a pre-trial. So, how long is he in DOC?
For a while.
No. Bond was set at 50,000, 10%. That will continue. Any additional matters for the record?
Nothing from the people. Thank you.
Nothing for the defense. Thank you.
Thank you. You're all set. Pull up the state of Michigan versus Felipe Giannis Martinez 24-006884FY. Appearance for the record, please.
Gabrielle Bell, Assistant Prosecutor for the people.
Senator Jeff Kaplan, P 74943, on behalf of the defendant who's standing to my right.
Today was the date that was set for a preliminary examination for controlled substance delivery manufacturing. And we're ready to proceed. Is that correct?
We are, Your Honor.
Okay, preliminary matters.
Yeah, Your Honor. I'm sorry. There was an offer made by Ms. Ezel in this case. If my client was to plead to an added count 2, which would be possession of cocaine, 25 to 49 grams, which would be a 4-year felony. If you successfully pled or dismiss count 1, I have estimated guidelines currently as charged at 55 to 127 months as a habitual third offense. I advise my client that also raises maximum 40 years. With the deal, I have estimated guidelines at 0 to 25 months. As a habitual third, that would increase the maximum to 8 years. I've advised my client that if he decides to run the exam, that the plea offer is withdrawn. He understands that, correct?
Yes. Yes, Your Honor.
And he respectfully declines that offer, Your Honor. Would like to go ahead and use it.
Preliminary matters. You call your witness.
Thank you, Your Honor. The people called to the stand Officer Tyler Tenbrick.
Your Honor, oh, sorry.
Okay, fine.
We do have one other issue, and I don't know it's going to matter, but in the event that there's going to be more than one witness, we'd ask for sequestration.
Okay. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You have more than one officer witness today?
No, Your Honor, it's just the one officer
Okay,
witness.
sounds good.
Thank you. Thank you for being here today, Officer Tenbrick. I want to just start with some background information. Could you tell us where you're currently employed?
Lansing Police Department,
And how long have you been employed there?
a little over 6 years.
And were you working on July 19th of 2022?
Yes,
And on that day, did you go to 1207 Furley Street?
yes.
And why did you go there?
We were assisting the South Lyon Police Department on a search warrant they're conducting there.
And is that location in the city of Lansing
Yes,
in Ingham County?
yes,
And that's in the state of Michigan?
yes.
Thank you. Now, when you arrived on scene, what was your role?
My initial role was just basically seeing security, standing by with occupants inside the residence.
And did that role change at all?
Yes.
And how did that change?
I was advised there was some suspected narcotics located in one of the back bedrooms, I believe the southwest back bedroom. And I was directed by my supervisor to go back there to collect that evidence.
And when you went back there, what did you find?
In a backpack in the back of the door, I believe, there was 3 bags, clear plastic bags with white powder substance, suspected to be cocaine inside that bag. And then there was 1 smaller bag on the floor, I believe, right by the backpack.
And talking about those packages, if I can just direct you to that first package, do you remember how much that weighed?
I don't exactly remember which package was which, but there was 1 package that was about package weight of 30.5 grams. There's another packaged weight bag, I think believe it's 14.5 grams. And then there was the other 2 bags was about 1 and then 2 other grams of package weight.
Thank you. And those packages were seized from the home?
Yes.
And what was done with those?
They were taken back to our Lansing Operations Center. They were tested with the True Narc, and then placed in evidence.
And what was the result of those True Narc tests?
Based on the True Narc, conducting the test, each bag came back as cocaine.
And those packages, you said some of them were found in a backpack?
Yes.
And was anything else found in that backpack?
I was advised that there was paperwork of some sort. I can't exactly remember what kind, but with the name of.
Your Honor, I would object at this point. If the officer doesn't have firsthand knowledge, he can't testify.
The objection is, you say.
Your Honor, I do believe that this officer does have firsthand knowledge to this. He did eventually see those papers. And I was hoping to get to that point.
Okay, I'll hold the objection while you lay further foundation.
Thank you, Your Honor. Did you review the contents of the backpack?
I did search part of the backpack, yes.
And did you take pictures of the contents that were, or the items that were found inside that backpack?
Yes.
And was one of those items a piece of paper or multiple pieces of paper?
Yes.
And do you happen to remember what those pieces of paper had on them?
The name of Felipe Yanez.
Thank you. And after you found that name on the paperwork, did you do anything with that information?
That was, I think the paper was just photographed for evidentiary purposes.
Thank you. At any point, did you run that information through any police systems to identify a suspect or confirm an identification?
I don't recall if I did specifically or not.
Okay, thank you. No further questions, Your Honor.
Thank you. Processing.
Thank you, Your Honor. Officer, you don't know who resided in that room, correct?
I do not.
Was anybody there other than law enforcement at the time of the search?
There was at least one female. I can't recall if there was any other occupants. I know there was one female.
Okay. The substances that you found, the True Narc, you said there were 3 bags, or there were 4 bags, 3 in the backpack and 1 on the ground by the backpack.
Correct.
And you were the one who collected those for evidence, correct?
Yes.
And how do you collect those?
Conduct our gloves and then just place them into some sort of a secure bag or plastic bag or paper bag to bring back to our operations center.
Okay. Those bags are sealed?
They are sealed once they're placed in evidence. Yes.
Okay. Who brought those bags back to your, was it the command center?
Our operations center. Yes, that should have been myself. Yeah.
Okay. When they get back to the operations center, what happens?
So initially you would go into our evidence room. That's where the True Narc is. You test the bag of substance inside with the True Narc. And then at that point, you would enter that information, weight, suspected narcotic, and into our evidence system. And then they are heat sealed into usually a plastic K-pack bag, it's called. And they're placed into an evidence locker where they are locked. Right there, padlock.
And were you the one that performed that entire operation in this case?
Yeah.
Okay. Once they are put in the evidence locker, what happens to them afterwards? Anything?
I don't know the entire process. Usually they are taken down to our evidence
quartermaster, which is here downtown in City Hall. We have a 4th floor in our police department here. They're retained in the evidence locker there or secured there, and then usually they're either sent to the lab or just retained until further.
Do you know if they were sent to the lab? And when you say the lab, you're talking about the Michigan State Police Forensics Lab?
Correct.
Okay. Do you know if they were sent there in this case?
I do not know that.
Okay. I think that's all I have, Your Honor. Thank you.
Did we ever, I don't know if he ever testified to the weight.
Your Honor, I do believe the individual weights were testified to, but the overall weight of the combined packages was not.
And you have your witness refresh me as to what the weight was. I don't have it noted.
Absolutely, Your Honor. Officer Tenbrink, could you just run us through the weight of the packages again?
And one bag was 30.5 grams, but that's package weight. There's another one, 14.5 grams, again, package weight. And then 2 grams package weight, and then 1 gram package weight.
The redirect of your witnessing.
Just briefly, Officer Tenbrink, when you went into that back bedroom, was anything else found in that bedroom that was notable?
I believe there was a digital scale located, I believe, on the bed in that room, but I don't believe anything else, so no.
Okay, and based on your experience, what's the significance of the scale?
Scales, are used to obviously weigh things, but in circumstances where narcotics, obviously to weigh narcotics.
Thank you. No further questions.
His witness be excused.
You may, Your Honor.
Thank you, Officer Tenbrink.
Thank you.
Any additional witnesses?
No, Your Honor.
Is the defense calling witnesses today?
No, Your Honor. Defense counsel.
Argument. Thank you. Your Honor, at this time, we do believe that the state has proved the standard of probable cause to show that Mr. Yanez Martinez did deliver or had the intent to deliver less than 50, or I apologize, did possess with intent to deliver less than 50 grams of a mixture containing cocaine. We believe we've met this probable cause standard, as we did show that the backpack where the drugs were found did contain paperwork with Mr. Felipe Yanez Martinez name on it. Inside that same backpack were 4 different packages of white powdered substance. All that ended up totaling about 48 grams, if my math is correct, which is less than 50 grams. And all 4 of those packages did come back with a true narc positive test for cocaine. The officer today was not able to provide an in-court identification of Mr. Yanez Martinez, as he was not the arresting officer. However, we do believe that the probable cause to believe the backpack was Mr. Yanez Martinez supplies that identification for bind over. Thank you.
All right, we would disagree. It's certainly not beyond comprehension that my client's backpack was stolen, or for that matter, somebody's got to be in here to identify that he is this Felipe Yanez Martinez who belongs to the backpack. I don't know how common a name this is, but there still has to be some identification of my client that hasn't happened. Secondly, Your Honor, for the delivery of controlled substance, there's no evidence that there was any delivery here. Apparently, the charge is simply based on the amount and the fact that there was a scale. But, back in the day, and I'm aging myself here, but you used to go to the grocery store and weigh products that you were purchasing to know how much you're purchasing. So it's not the scale in itself. I don't think it is evidence of delivery. Could be for purchasing.
You said for purchasing?
Well, that would be a lesser charge. It wouldn't be delivery or manufacture. And that's what she's charged with here, or he's charged with, is delivery and manufacture. Possession is different. So to prove delivery and manufacture, they have to prove that the defendant transferred or attempted to transfer the substance to another person. No evidence of that in this case. Then he must have intended to deliver the substance. And I'm reading jury instruction 12.2, subdivision 2, Your Honor. Second, the defendant must have taken some action towards delivering the substance but failed to complete the delivery. And I'm not going to read the rest of that there, but there is an additional language there. It's not enough to prove that we made reparations and so on. Second element is the defendant knew that he delivered a controlled substance, and third, that the controlled substance that he delivered had a certain weight. So we don't think that they proved by a probable cause standard that he delivered. I don't think there's any evidence of manufacture here. And again, jury instruction 12.1 relates to the manufacture of a controlled substance. And they have there's going to be evidence that the defendant manufactured it. And there's just no testimony to that at all. So we don't think that there is enough evidence here to support that charge, Your Honor. We'd ask for dismissal. Thank you.
Re-argument?
No, Your Honor, not at this time.
Where's the officer who was supposed to identify?
Officer Tenbrink was the only officer that we subpoenaed for today's exam. Based on the report, it's very unclear who did the arrest or was able to arrest Mr. Yanez Martinez.
So this is the concern that I have. The purpose of this exam is to establish probable cause that a felony was committed, and then also probable cause that this is the person who committed the felony. You don't have an officer here who can identify that this is the person that was either arrested, or we don't have any evidence that identifies that this was his house. Counsel for the defense makes a valid argument that what if his client's backpack was stolen? We don't know how common this name is. You know what also is common? That maybe it was his dad who has the same name. I don't know what his dad's name is. There's so many possibilities that could have easily been flushed out by having an officer who was here to identify that this is the person that was either arrested, or that there was some additional information as to who actually lived at this address of 1207 Burley Street. That's the first concern that I have. And I recognize only one officer was subpoenaed, but if officers are going to bring a affidavit of probable cause to the prosecutor's office, then they should be able to provide some additional information as to who actually is able to identify. You gotta identify even at trial. So if you can't identify at this point, because it's unclear at this point which one actually did it, then I don't see the reasonable likelihood of success at trial on that identification issue. As to the elements of unlawful possession of a controlled substance with intent to deliver, we obviously have a backpack here based on the testimony that was located in that backpack, having tested positive for having 3 bags, I think, of white powdery substance that was containing positive for the substance of cocaine, and then at least 1 other bag outside of the backpack area, I guess. And that backpack also contains some paperwork with the defendant, or the name, I should say, Felipe Yanez Martinez on it. No clue what the paperwork even is that contains his name. Is it paperwork that says that maybe someone wrote his name and number down? I don't know what this paperwork is that makes me believe that this was his backpack. If it was his ID or a bill or something else that made me feel like this is personal information that someone would place in their backpack, their own purse, that's one thing. But just to say there was some paperwork with his name on it is extremely vague and ambiguous. And so I don't believe that there's sufficient probable cause at this time. So the matter is dismissed.
Hey. Oh, sorry.
Thank you, Your Honor.
Thank you, Your Honor.
But you need to get him a dismissal. If he wants to hang tight, we'll get him a copy of dismissal real quick.
Thank you, Your Honor.
There's a lot of excitement from the jury box, so I'm assuming there's gonna be some excitement on her own case as to how we're gonna move forward. Do we know what we're doing?
We're gonna be entering a guilty plea, Your Honor, as to the original
Mr. Nagel.
request, the original production. Thank you.
Thank you.
Your Honor, I just want to apologize for speaking over you. I got a little eager with the point I was trying to make, and I jumped the gun there. I had no intention of trying to interrupt you.
No worries, there's a lot of excitement in the courtroom today. You missed a really big outburst from Ms. Forrest.
Oh,
She was excited for
Another defendant,
another defendant's
positive.
lack of probable cause, so I can appreciate her celebrating
I was gonna say, a little
justice on behalf of someone else, I guess. I can appreciate that.
bit of
You gotta-
solidarity can be a good thing.
You gotta control your outbursts. And
Your Honor, thank you.
practice celebrating it on the inside. for other
Not quite,
people.
Ms. Forrest, not quite.
Okay, back on the record in the matter of the state of Michigan versus Ashley Forrest. We went off the record because the no contest plea went very left, and my understanding now is there's gonna be a guilty plea.
That is correct, Your Honor, for speaking further with Ms. Forrest and yes, Your Honor.
Is anybody threatening you to plead guilty now to the amended charge? Any promises being made if you plead guilty? Okay, and so as to the, and I've already gone over your rights, you have a full understanding of your rights. Do you have any questions about your rights at this time? Okay, as to the amended charge of receiving, concealing stolen property less than $200, how do you plead?
Guilty.
Have a factual basis, please.
Hang on. Okay,
You need the police report back?
if I have it on my computer. I probably should get that anyway, Your Honor.
I mean, already.
Yeah. Right, Ms. Forrest, I'm gonna ask you some questions. Ask you to speak up on your answers, okay? All right. All right, so Ms. Forrest, back on November 1st, 2024, at around 10:35 in the morning, were you at or near a location of South Martin Luther King Boulevard and Warwick Avenue?
Yes.
And that is located in the city of Lansing County, Bingham State of Michigan?
Yes.
And at that time, you were driving a Buick LeSabre, correct?
Yes.
And at that time, you did not have any type of paperwork regarding your ownership of that vehicle, correct? Okay, and at that time, you were pulled over by a police officer, is that correct?
Yes.
And that was after you had pulled into a random driveway, correct?
Yes,
Okay, and you initially said that you did not, that you initially said that you had purchased that vehicle from someone, correct?
Yes.
And but at the time you purchased that vehicle, you had reason to know that that vehicle was
yes,
stolen. Okay, and the reason was is that too cheap, right? Okay, and the fact of the matter is, it was just, it seemed like it was too good to be true.
Sure.
Yes,
Yes.
okay, and you had that, you took that vehicle, you had that vehicle at that point with not the intent to return it to anybody or report it, correct?
Correct.
All right, thank you, Your Honor. If the court or the prosecutor make further questions.
Any additional questions?
We're satisfied.
Court is satisfied with the factual basis. I'll accept your plea. Find your plea be made fully, voluntarily and intelligently. This matter will be set for sentencing. Do we need a restitution hearing, or will that amount be provided?
I guess I will need to know first, because I indicated earlier, we don't have any documentation regarding damage to the
I was
vehicle.
gonna say, what exactly is
So I don't
restitution
know.
for?
Going
Apparently there was a new muffler that had to be installed and there was additional damage. I will have paperwork to justify the restitution. And if there is need for restitution hearing, could be scheduled for the same day as sentencing.
You said there's a new muffler that needs to be installed?
That has been installed to the vehicle. That was supposedly caused by damage since the vehicle was stolen from the owner. If there's need for a restitution hearing, Your Honor, it's the defendant's right. Could we just schedule it for the same day as
I
sentencing?
want a restitution hearing on this muffler. I want to make sure the muffler wasn't needed before the allegations of. it
That makes
being
sense, yes, Your
stolen.
Honor.
Yes,
Set up a restitution hearing and sentencing.
I didn't hear it. I sentencing date. Your Honor.
We didn't, I don't think I provided it. It's gonna be April 10th at 9 AM.
Thank you, Your Honor.
It should be held on something else other than this. She has to be because it's a PR violation.
well, I think the bond was remanded when she was picked up.
Got it.
I believe as of the 31st of January, when she,
Oh, she failed to appear on the 17th. Let's see. And then arraigned on the 31st. How did she end up in custody on the 31st? So what?
I was pulled over.
and she had an outstanding situation from 55th District Court in addition to here. I
You
would,
got pulled over, you were driving again?
I was with somebody.
Oh, okay. And so you had an outstanding in here and in 55th. Okay,
if I may be heard, Your Honor. The bond.
yes.
Thank you, Your Honor. It's my understanding that she is being held no bond on this file due to the failure to appear. She currently does have a cash surety bond for $25,000 out of the 55th District Court. That matter has been, as of Tuesday, pardon me, was waived up to the Circuit Court. It is not related to this file in terms of the charge type. I would ask the court, we're not asking for a PR bond. We would just ask that the court consider some type of bond so that she may continue to accrue credit, as she does not anticipate being able to make that bond in 55th District Court, or not the 30th Circuit. Thank you.
5,000, 10%.
25,000.
Okay.
Cash surety.
All the bond conditions will continue. Any additional matters for the record today?
No, Your Honor, thank you.
If I could get the sentencing date again, Your Honor, I apologize.
April 10th at 9 AM.
At 9 AM, thank you. And that also is going to be the restitution hearing date?
Yes.
Yes.
Thank you. Oh, your other, yeah, you're supposed to be getting that. Looks like the attorney who's worked with you on Tuesday, he did put a request in to get it sent to you.
Okay.
It just hasn't happened, yet, but it is in the process, okay?
Oh, girl, yes. How come when I looked at my docket that was emailed to me, it was much longer than this?
And we did the